On the 29th of March, Prime Minister Scott Morrison made it clear that he'd like to see landlords and tenants sit down and work out solutions to survive the Covid-19 period. The starting point is that nobody should assume that their lease, or any contract for that matter, ends automatically because of Covid-19. Most landlords and tenants will remain in a binding lease. There may, as with most things in law, be exceptions. Every lease and every arrangement is different. That's why it's so important to get specific advice in relation to your particular lease and circumstances. The best approach is to seek to agree on a mutually acceptable solution to both the landlord and tenant. COVID-19 is neither party's fault, and each party will have their own financial pressures. So I really encourage people to approach any discussion or negotiation with a sense of empathy for the situation that the other party is in. Now is really the time for a commercial approach, cool heads, and a level of practicality to finding solutions. I have considered some frequently asked questions from a landlord's perspective. I hope this serves as a useful starting point, but I can't stress enough the importance of obtaining specific advice. For example, your particular lease may have a provision which means the answer to one of the questions is entirely different because of a specific clause in your lease. As part of the Prime Minister's announcement for commercial landlords and tenants, there's a 6-month moratorium on evictions. We haven't seen the finer detail of this as yet, but there is a set of commercial tenancy principles. In the links below this video, I've included a link to the media statement with those commercial tenancy principles. As a starting point, I'd recommend you get in touch with your insurer or broker and find out if you have cover. It's possible, because of the terms of your policy, that if you enter into an arrangement with your tenant for reduced rent or deferred rent, that this may mean that you're not covered under your landlord's insurance policy. So before you start negotiations, that's a very good place to start as a landlord to find out what it does to your cover in the event you do reach an arrangement. Question 1. Can the tenant ask for a reduction or a deferment in rent? Yes, the tenant can ask. This is what Scott Morrison has encouraged a discussion on, to see if the parties, the landlord and tenant, can reach a mutually acceptable solution. This may be brought about by a discussion between the landlord and tenant, maybe a discussion between the tenant and the property manager, or a discussion between the solicitors of both parties. Once an agreement is reached, this should be well documented. Speak to your solicitor about the best way to do this. Typically in Queensland, this would be done by way of a deed of amendment or a Form 13 amendment, which is a titles office form. Question 2. Will costs that I incur because of COVID, like more frequent cleaning, deep cleaning, hand sanitizer, be recoverable as outgoings under the lease? This will depend on whether outgoings are recoverable under the existing lease and the definition of outgoings. Where cleaning costs or consumables are recoverable under the existing lease, it's likely that these will be recoverable from the tenant, provided the landlord acts reasonably. In respect of areas maintained by the landlord, for example common areas, additional cleaning and other reasonable steps might be required in those areas for the safety of the users of a building. In most cases, where those costs are incurred reasonably and appropriately, those costs will be recoverable from tenants who must pay for those outgoings under their existing leases. Question 3. Can you force a tenant to continue trading? Essentially, no. While most leases have a clause requiring the tenant to operate or continue to trade, it is highly unlikely that a court would grant an injunction, which is an order to do something, or sometimes not to do something, in relation to continuing to trade in these circumstances. However, that doesn't mean that the tenant ceasing trade is okay. It may be that that is still a breach of the lease and may entitle you to a damages claim as against the tenant. However, there's probably a difference between a tenant choosing to close in order to be as safe as they can be versus having to close because of a legal requirement. In most leases, the tenant is required to comply with official requirements, laws or regulations affecting them. In this case, we might have an inconsistency between the obligation to trade and the obligation to comply with laws and regulations. In these circumstances, it's likely that the requirement to comply with official requirements will prevail over the requirement to continue to trade. In that case, where the tenant is required to comply, a landlord will not be able to force a tenant to continue to trade. Question 4. Can the tenant argue the lease is frustrated and at an end? The doctrine of frustration of contract is a common law concept. Common law being the body of law that's been developed by a bunch of cases over the years outside of specific legislation. Frustration occurs when, through no fault of the parties, an intervening event occurs which makes performing the contract radically different or impossible. Typically, a temporary closure is not going to amount to frustration of a lease. However, it's going to depend on the circumstances. A 3-month closure in the context of a 10-year lease is unlikely to amount to frustration, whereas a 5-month closure in the context of a 6-month lease may well arguably constitute frustration. Question 5. Can the tenant argue that you've breached your promise to provide quiet enjoyment? No, in most cases. Quiet enjoyment is what the tenant is typically entitled to. Enjoyment of the premises, free from disruption from the landlord in most cases. However, under most leases, the parties need to comply with official requirements, and it's likely that compliance here will not amount to a breach of the promise by the landlord to provide quiet enjoyment. The situation, however, might be quite different where you as a landlord choose to close a centre down before being legally required to do so. And if you are considering this, I recommend you obtain very specific legal advice and document your actions very well, because you will be taking some risk that you are disrupting your tenant's ability to enjoy their premises, and therefore you may open yourself up to a claim from that tenant who is disrupted. Also, if it's in relation to a retail shop, there may be specific rights to compensation, which we'll discuss next. Question 6. What if I have a retail shop? Will I have to pay my tenant compensation? Under Queensland legislation, the Retail Shop Leases Act, there are rights to compensation in certain circumstances if the landlord substantially restricts the tenant's access to the premises, takes action other than under a lawful requirement, which has the effect of restricting access or the flow of customers past the premises, or causes a significant disruption to trading. Notice that this legislation is focused on actions taken by the landlord. There is also an emergency exception, so the landlord may not be liable even though they've caused those effects. A landlord will not be liable to pay compensation where their actions are a reasonable response to an emergency, or where they've done that thing as part of a requirement under an act. Therefore, a landlord who is legally required to close a centre or premises is highly unlikely to be required under the Retail Shop Leases Act to pay compensation. Where a landlord proactively or preemptively closes a centre or premises, the answer is a little more uncertain. Landlords will need to exercise care and make sure that they're documenting their decision very well. Essentially, a landlord will need to balance up its obligation to provide the premises to the tenant with the need to balance health and safety concerns. For example, if a particular centre had certain circumstances, such as a particular outbreak in that centre, it may be that it's appropriate to close the centre, but that doesn't necessarily mean that the landlord would escape liability to other tenants that are affected. It's certainly possible that these types of issues might be able to be handled best by really good communication and a negotiated solution or arrangement, rather than later recourse through the courts, because naturally through this COVID-19 period, the courts are not operating in exactly the usual way that they do, and there may be further delays or issues with access to the courts, and so wherever possible, negotiated solutions should be pursued rather than relying on a judge to ultimately determine what should happen. Question 7. What if you're a landlord and it's actually your self-managed super fund that holds the land? I won't spend a lot of time on this issue, but essentially if you're a self-managed super fund, meaning that the trustee who owns the land is trustee for a self-managed super fund, there are some special rules which typically would apply. For example, there could be some real issues around a related party tenant and granting them some form of rent reduction. For example, there were some concerns flagged about related party tenants and whether there would be able to be rent reduction or rent deferment arrangements put in place, and whether that would breach the sole purpose test that self-managed super funds have to comply with. This is certainly an issue that you should seek advice from your usual solicitor or accountant, but in short, the ATO has reassured people that they will not be taking compliance action in relation to rent reductions or rent arrangements, like Scott Morrison referred to, in the 2020 and 2021 financial years. However, if you do have a related party tenant, the most prudent approach would be to approach that in much the same way as you would an arm's length tenant. So keep your eye out for further updates, stay safe out there, negotiate with empathy, and be kind to each other. Cheers. Fox out.